My name is Ravi. I'm from Armchair Criminal, and I welcome you all to this part of the program. This is the third part of a four-part series on res gestae, and this is the second section of common law exceptions to the hearsay rule. We considered the legal framework, and in part 2 we considered further material with regard to the importance of time, but we are going to expand on this even further and look at some of the other concepts. Here we will look at the mental state of the person concerned and limitations of that concept in the context of res gestae. Therefore, at this juncture, I pose the question: what is section 118 subsection 4c permits? The answer is there are 4 points to consider, and when you look at section 118 subsection 4c, it reads: the statement relates to a physical sensation or a mental state such as intention or emotion. Therefore, the next what we really should consider now is what is allowed to be adduced as elements in section 118 subsection 4. What I would say is it is difficult to define, but at least there appears to be 4 categories that can be identified, and there is some overlap between them. First is the physical feeling of the person. This could be pain and suffering, injuries, physical sensation, pleasant or unpleasant. Then the mental state, such as the anger, the rage, the fear. Then the intention could be that of anger and what the person hoped to do and wished to do. Finally, we come to the area of emotions. Equally, emotions such as sadness, tears and fear, it is important to understand that whilst we use our voice to express our feelings, but at times our best form of communication is through the body language. Therefore, one must not forget the importance of demeanor. What we will now consider is what appears to be the limitations in adducing material under section 118 subsection 4c. It appears that the time of the relevant physical sensation or mental state could be important. What one can describe is one's feeling, emotions, intentions, but what they cannot do generally is to describe the cause of it. Then there are limitations as to how the statements made by a defendant could be admitted. When we look at the next section of this 3-part series on confessions, you will understand that confessions are admissible but not exculpatory statements by the defendant. I'm not going to dwell on that here because we will be exploring that in greater detail when we consider the topic of confessions as a separate section. Next, we will ask ourselves, what is the difficulty in timing of the events? The difficulty is that is a question of fact. And as a question of fact, the timings could be relative to the incident. As a general rule, contemporaneous feelings, emotions are admissible. However, as the timing is a matter of question of fact, whether the statement can be contemporaneous or not will be considered by looking at the case in its entirety, taking everything into account. The case of Black, this was a murder case, and her husband was indicted for the murder of his wife. Prior to her death, she had accused him being responsible for her condition. And he has not replied. Therefore, that statement was admitted in evidence. He was convicted and he appealed. The court held that contemporaneous not to be confined to the feelings of the person who's experiencing it at the actual moment, but it could include some past events. So that is something to be borne in mind. The way in which Section 118 has expanded and evolved really comes to light when one looks at the case of Barnaby, Morgan, and Ibrahim. These cases, and in fact there are other cases too, really put low darkness dictum in its context and how valuable that judgment was. In the case of Barnaby, this is a domestic violence case. There was a call at 6:33 and 6:49 in the morning of the incident. There was a female on the phone basically whispering, saying, I really can't talk. I have the authority here just to make sure that I got everything correct. I really can't talk. I've just been attacked by my boyfriend. Then the second phone call said, my boyfriend just strangled me. I really can't talk. And then she refused to give her name. And on the third call, she said that her boyfriend has just left the premises. And at 6:49, the police officers arrived, literally 6 minutes from the last phone call. And the police officers noted that her demeanor, her condition, and they also felt that she was anxious, that if the police were to arrest Barnaby, and fearful of what he might do if he is not arrested and allowed to return to the house, because in the past she has suffered for making complaints against him. If I recall other facts of the case, she didn't give a statement. However, on the day of the trial, she turned up at court. Neither the prosecution nor the defense called her to give evidence. Remember that she was frightened of what could be the repercussions should she give a statement, and if he comes to know that she has cooperated with the police. And the application was made to adduce the phone call, the body worn footage, everything. Equally, she had made a comment to say that he has a large amount of drugs on him, which proved to be wrong. And not only that, she claimed that he has been to prison in the past for doing similar things to her by way of domestic violence. And she had told in that condition that he is only going to get away with it, and that has happened in the past, and the same thing will happen on this occasion. The learned court allowed the evidence in, and eventually he was convicted and he appealed. The High Court very clearly went through very carefully how the trial court has applied the rule, and taking into account her demeanor at the time and what she has told the police, and their observations of her was taken into account. And the court said, the High Court said, nothing wrong with what has happened. It was perfectly legitimate to have come to that conclusion, and the evidence was properly admitted. One of the grounds upon which the defense argued is that they cannot cross-examine the complainant. Yes, it is true that just because it's mere res gestae, you cannot do away with witnesses. But if there is a genuine fear and the prosecution is not merely putting res gestae to overcome the need to call the witness. In other words, if there are genuine reasons for not calling the witness, then that is fine. Here, the court observed what the complainant has said, how she has felt what could be the consequences of she giving evidence. And in order to determine that, the High Court considered the rule in Attorney General's Reference Number 1 of 2003, EWCA 1286, and said yes, the defense can make an application to exclude the proposed res gestae evidence. But if the court is satisfied that it is not done in order to frustrate a legitimate claim for cross-examination, in other words, the prosecution got legitimate reasons to avoid, just like in section 116, fear, then it is perfectly legitimate to rely on res gestae principle. Therefore, when the prosecution said that they do not intend to call the witness, question that is important. Don't let the prosecution just merely say this is res gestae and that's all we need. No. They might be able to, but don't take it for granted as it is a given fact that they can do it automatically. No. Challenge it. And on that basis, the prosecution was not using unfair tactics to avoid introducing evidence that was potentially inconsistent with the case against the defendant. Because here there was evidence to support what the complainant was saying. The next authority that is worth considering is DPP and Morgan. I got the authority here again. Let me just get that. This was by way of case stated from the district judge sitting at Manchester. Again, this was an allegation of domestic violence and criminal damage. The complainant had made a 999 call, sounding very distressed and difficult to speak coherently. And the police arrived. The body-worn video was running, and that overlapped with the call to the 999 emergency system. The complainant had initially run out the house and hidden outside. So there has been a slight delay with regard to the comments that she has made, what constituted as res gestae. And when it came to trial, the prosecution served a witness summons, yet she didn't come to give evidence. And the police had noticed that she had been very upset, burst into tears, saying that she did not want to go to court, go through it all over again, and to relive the ordeal. The person who served the witness summons thought that it was genuine. And there was evidence when the police came, the damage to the door, tobacco was scattered everywhere in the house, and they had photographic evidence of the injury to her eye and her knee. The question was, by way of case stated, the learned district judge asked, was I right to admit under res gestae principle the complainant's hearsay evidence contained in A. 999 tape, B. the body-worn footage? Question number 2. Having admitted the hearsay evidence, was I right to refuse the application to exclude it? 3. Was I right to find there was a case to answer? Number 4. Having heard the evidence, was it permissible that I made the findings of fact which I did and convicted the defendant of both allegations? There has been some delay of bringing this case to the High Court because of some difficulties the defense solicitors had. Again, applying the authority of Andrews and Barnaby, then there's another case by the name of Ibrahim, which I will consider next. The court found that the mere fact of delay is plainly a relevant factor for consideration, but it is not necessarily the determinative of the issue before us. There you are. Yes, timing is important, but it is not the decisive point. The decisive point is whether the person is so emotionally overpowered to exclude the possibility of concoction, fabrication, distortion. What the court will do is apply Section 118, paragraph on res gestae, which does not really talk about timing. What it talks about is possibility of concoction, distortion. If they can be disregarded, then the answer is yes. The court also considered low darkness judgment quite carefully, such as spontaneity, then special features in the case, and the High Court found that the learned trial judge had those passages in mind and considered them very carefully on the issue of delay. The court also felt that, notwithstanding the slight delay, that still it is within the rules of res gestae. So one must understand that it is important to bear in mind the time factor, but that alone will not give impetus to exclude res gestae just because of a slight delay. And this will become more apparent when we look at the case of Ibrahim. And in fact, on paragraph 29, this is what the court said. It seems to me that of the arguments put forward by the appellant in relation to the possibility of concoction or distortion, that the question of delay was the most significant. I am unimpressed as to the point about vagueness of the complainant as to the damage. One would not expect a complaint in a distressed state to deal with the matter in forensic detail. The matters raised by the appellant in interview, posing an alternative scenario, were of secondary importance at the admissibility stage. And the fact that an officer had posed questions at the end of the process to obtain a more coherent account overlooks the facts that by then the complainant had already made her allegations against the appellant in the 999 code. So the mere fact that there has been a slight delay of speaking to the officer, that didn't make a difference. The next authority that I would look at is Ibrahim. Ibrahim is another case where it was a domestic violence. In fact, there was 1.5 hour delay in making the phone call to the emergency services. And on behalf of the appellant, submissions were made that the call did not fall under the principle of res gestae because of the time frame. Namely, he had left the house at 9 p.m. The call was made at 10:25. The police arrived at 10:45. Therefore, on behalf of the appellant, it was contended that it was not a continuous transaction. Again, the High Court dismissed the appeal and said that question was to be answered by looking at the circumstance of the statement. Timing of the event was relevant factor, but there might be other factors which related to the concoction or distortion. And here, because of the circumstances that the complainant had suffered, including from her own mother wanting to interfere in this situation, the court said that the learned judge had taken all the facts into account. As to the question of time, the judge had referred to the victim being hysterical on the call, her recent injuries that were still developing before the attending officers, the disturbance to the flat, and her demeanor when the police arrived was considered. That was sufficient evidence on which the judge could conclude that the victim's injuries had been sustained in a time frame such that concoction can be negated. So it is important to understand not merely just the timing, but look at the facts in the context of the case. That is why I gave an example in part 2 where a domestic violence takes place during the pandemic. The complainant and the assailant are both locked in the house because people cannot go out. Consequently, it would be unfair to rule the complaint that the victim is making, given the first opportunity that is available. Because if the person is locked in with the assailant, the complainant would be in fear of making the call and suffering right throughout. It's a question of fact. Now, the next is what can be described by way of emotions, feelings, intentions. It is the physical feelings, emotional feelings, fears, intentions that can be described. When we considered the case of Black, it illustrated the point that how the complainant describing how she was feeling soon after the medication was given. And equally, in the case of Barnaby, the court relied on body-worn video as well as the testimony of the officers as to the demeanor of the person, even though that she did not give a statement. And when one considers the case of Everson, I have the authority, but if I recall correctly, this was a fraud case where an insurance policy had taken place in favor of the deceased for the benefit of the defendant. And there has been a medical assessment by a doctor. However, the complainant not the complainant, the deceased, had made comments to another person how she has been feeling at the material time. And that was allowed by way of evidence. Equally, there's a case of Edwards where the neighbors received information from the deceased, basically in a hysterical condition, how she has been in fear because of her husband making threats with various weapons, and how she felt safe or feels safe when those items are out of sight. What is important to note there is, in that situation, the court has allowed not only her feelings of fear, emotions, but the cause of it too, which I said at the beginning, generally it will not be allowed. My only assessment of it is that in order to understand what she's saying, what she's expressing, you got to be given the information as to the cause of it. Otherwise, on its own, might not make sense. The next case is Neil and North Antrim Magistrates Court. This is a case from Northern Ireland. If I recall correctly, There were two young witnesses. I have the authority somewhere. Two young witnesses witnessed the incident, and the police wanted to call them as witnesses at trial. But their mother told the police that they are frightened and will not be giving evidence. That evidence was admitted and the defendant appealed. The appellate court, the House of Lords, eventually held that the evidence was wrongly admitted. If the police officer had spoken to the boys and given evidence in court as to what they say, then that would have sufficed, or could have sufficed. But here, what the police officer is narrating to the court is not what the witnesses say, but what their mother is saying. So you have a situation, it's hearsay upon hearsay. For that reason, the court said that that is not acceptable. Then the case of Higgins. I have the authority here, let me just remind myself. This is again a domestic violence case. The complainant, the wife, was covered in blood and had a broken nose. The man claimed that he acted in self-defense, and he appealed for admitting the evidence that was made by way of res gestae, claiming that it was her husband who had struck her, causing the injuries. The court held that it was admissible because she was so emotionally overpowered, and the possibility of concoction distortion could be disregarded. Equally, the court noticed that she was highly emotional at the material time. The court said that the judge had approached it correctly. First, that the court was satisfied that it is him who has assaulted, and that he was not acting in self-defense. Therefore, when it comes to considering, one must look at the entire situation of the case, without which it will be difficult to judge not only the timing, but the demeanor of the person, the circumstances, how difficult it was for the person to contact the emergency services or anyone else for that matter. Any other independent evidence that could corroborate, like injuries, the house being in complete disarray, any marks on the body, bruises developing, which could all add up by way of confirming, corroborating the account the complainant is giving. Having said all that, please do not accept that the prosecution has a right not to call the witness, but just simply rely on the res gestae. What these cases also show is that if the defense is pleading self-defense, one must be careful how it will plan out. I accept that when one pleads self-defense, the prosecution is obliged to negate the defense of self-defense. However, it doesn't necessarily mean that they cannot establish that offense without calling the complainant. If there is independent evidence, the mere fact that the complainant doesn't give evidence with res gestae in, the case is made out. That is all I propose to discuss at this stage. Next, we will consider the final part of this 4-part series on res gestae, and there we will look at such topics as the intention, how that could operate, and that should cover the relevant material for res gestae. Of course, there we will look at how the statements made by the defendant is considered by the court very briefly, because we will be looking at confessions as a separate section of its own right. And we will also consider there whether the interest of justice needs to be considered when one looks at res gestae. I hope you have enjoyed this part of the program. Thank you for your valuable time. I look forward to seeing you again. Thank you and God bless.